Right, good afternoon and welcome to BNI Forward, Powerful Together, a series of webinars organized by BNI UAE. For you, our BNI members, and it's also open to any non-BNI member who would like to participate in this series. We've had almost 1,000 attendees over the last 6 weeks, including today, and that just shows that we've been bringing something very useful for you, that you would have some insights and learn something as we go along with these webinars. And I'm glad, and the team is glad, that you made it so successful for each and every one of us. As you know, this is a series of webinars brought to you by BNI UAE. It covers two components. One is the wellness sessions, which happens every Monday. And we also have the business sessions that happens on a day like this, a Thursday afternoon. And we're glad that you could have joined us, and we welcome you. Today, just before we kick off, I'd like to run you through a few pointers. One is, please ensure that you have a high quality headset so that you're able to hear our speakers well. Make sure you got a good internet connection. I know bandwidth can be a challenge in these times. And we also have the Q&A bar. If you look at the bottom of your screens, you'll see a Q&A bar, and that's for you, our attendees, to place your questions. Just make sure that you mention the name of the person you're addressing that question to so that it can be addressed by the respective person. Those will be answered at the end of the Q&A session later on in the webinar. My name is Roshan, and I'm from BNI Synergy. I'm co-hosted with Suresh Raju. He's from BNI Rising Phoenix. And we are supported very well through a team comprising of Sam, Samrat Maharish, he's from BNI Insomniacs, Pradeep from BNI Champions. We also have Reem from BNI Rising Phoenix, Anna from BNI Evergreen, and Rocky from BNI Falcons. This is the team that brings you these webinars on a week-to-week basis as well. Today we have Deva Nand Mahadeva, who's our moderator for the afternoon, and he's from BNI Gazelles. He will be moderating the topic, which is navigating the legal and human aspects of HR. A quick glimpse of the speakers we have this afternoon. We have Elena. She's from BNI Evergreens, and she's the managing partner of Maya Roman and Partners. We have Adil Shafi. He's from BNI Gazelles, and he's the partner of AC&H Legal Consultants. And we have a BNI alumni from BNI Synergy, who now is chairman of the Nathan and Nathan Group, Mr. Preetham Gabriel. So this is our panelists for today, and they will be speaking on navigating the legal and human aspects of HR. Before we move on, I'd like to call upon Vijay to please give us a few words, and let's kick things off with Vijay. Vijay, over to you.
Thank you very much, Roshan, for that. Yes, today is our sixth business webinar that we're bringing you just before we break for Eid. And as Roshan mentioned, so far we've had over 1,000 attendees participate in these events, which is fantastic. So we're getting a lot of positive feedback in terms of the value that all of you are receiving, and we're really happy that you are. Of course, we'd like to continue receiving more feedback from you on these events and what else we can bring you, because we do have a great pool of experts on various different topics. Today's topic is, I believe, again, something very critical. It's all around HR, and the reason why it's very critical is it involves people. You know, especially in the current times, people in any business are the key asset. Without people, you don't get things done, the businesses don't run. And when we have situations like we're going through right now, looking after these people is very, very critical and important. At the same time, we also understand that businesses do need to make some business decisions. So it gets a bit tricky. And then, you know, we start getting involved in contracts, and we start getting involved in those relationships. So what we're going to be covering today is everything around the legal side, but also importantly, the human aspect of HR. And that's why we brought this panel of experts together who can walk us through the intricacies of how to deal with situations involving your employees, involving your people, what sort of decisions you need to make, how you want to make sure that both you and they are protected, and at the same time, having that empathy towards them. At the end of the day, they are the people who have, probably brought your business where it is, and what you do going forward will be a big factor. So without much further ado, I'd like to hand it back to Roshan, but I want to thank Elena, Adil, and Mr. Pritham Gabriel for their time today, and of course to Devanand for his time in moderating today's session, and all the people at the back end for making this happen. Thank you very much. Enjoy the session, and if I don't get a chance, I'd like to wish all of you Eid Mubarak for next week.
Thank you, Bijay. Right, just a reminder that this is going live on Facebook, and we also have a Facebook group, which is a private group, and you're encouraged to join us if not done so far. So let's kick things off, and I'd like to first introduce Elena Shildian. She's the managing partner lawyer at Meyer Rauman and Partners. Elena has over 30 years experience practicing in the UAE and across GCC regions, specializing in labor law, commercial agency and distributorship agreements, company structuring, as well as wills and probates, inheritance and family law, including the registration of wills and foundation with the DIFC. She graduated from the Faculty of Law at the University of Passau, Germany. For many years, her family was based in Saudi Arabia, which she followed her to gain continuous exposure to the Middle East. This, coupled with her interest in international private law, led her to seek the opportunity to complete a practical internship in Dubai for 5 months in 1990, when finishing her legal qualifications in Germany. With an international placement in Dubai, UAE, at Meyer Rauman and Partners, formerly Meyer Rauman Legal Consultancy. Please welcome Elena, and Elena, over to you.
Thank you very much, Roshan, for the introduction. It is a pleasure to be here and contributing to this initiative of BNI Forward and have the opportunity to speak about the important topic of navigating the legal and human aspect of HR. Good afternoon, everyone. I hope you're all keeping healthy and safe. A big part of this staying safe in these times involves, for many employees and employers alike, staying home from work because of the major disruptions COVID-19 has caused for most industries in most countries, if not in all, one way or another. As a consequence, employers all over the world had to review and adjust their business continuity plans, and in most sectors take immediate measures to respond to the impaired commercial activity, such as assessing the economical situation, considering the restructuring of workforce, and observe certain guidelines for implementation. We will look at each of the points and what this involves in detail. The first step every employer would be taking is to assess and evaluate the economic impact for each individual business and business sector. This will be different, and the level of impact will be different, resulting in possibly a temporary closure of the business, or, depending on the specific industry involved, such as events, travel and tourism and hotels, as a full closure of business. But even if the impact only leads to a slowdown in transactions, orders and sales in different levels, the income and revenue stream will be impacted, which in turn again definitely requires certain adjustments of the business operation to be sustainable in the forthcoming month and hopefully years. The operational costs for every business will also vary a great deal. However, I guess it is fair to say that next to rent, costs for workforce are a major part of these costs, leading to considerations to implement cuts or reductions. This seems to be sensible, but I would strongly recommend to evaluate all factors involved. And at this point, think about alternative measures prior to termination. Depending on the business plan and forecast, it may be at this stage possibly enough to reorganize intended hiring programs, possibly hold and delay offers for employment, reduce the number of temporary workers that you may have in place, and certainly also to find a compromise with the employees on bearable salary reductions. The thought behind this is one, that also a termination will involve possibly a considerable amount of expenses that the company will have to shoulder. Secondly, there will be a time when operations will be resumed and businesses will need to rehire, and at that point are facing the additional expenses of the process of visa costs and the whole rehiring process. Last but not least, you may want to protect your business also in a way that you just retain the talent that you currently have, and most probably invested quite a lot in, saving you the time, effort, and also expenses when eventually employing someone new again later. Certainly, depending on the level of impact on the business, there may be just no other choice than to identify potential redundancies. At this point, it is crucial that business owners are fully aware on the legal requirements, consequences, and risks. You will want to identify exactly what can be done legally and factually and which procedures you need to follow, meaning which notice periods you have to observe depending on the terms of the employment contract, what are the dues to the employee, including outstanding salaries, untaken leave, entitlements to repatriation back home, including personal effects, and most importantly, the end of service benefits. Lastly, I would want to point out that certain support measures announced by the authorities may provide some relief in terms of saving costs and expenses, such as reduced fees for services and license renewals. So it is always good to observe and monitor this and verify what may be exactly applicable in your business sector. One of the government measures to regulate the restructuring of the workforce was the introduction of Ministerial Resolution number 279 of 2020. And this is I quote the full title, regarding the stability of the employment in private sector companies during the period of applying precautionary measures to contain the spread of the novel coronavirus, and this is effective since March 26, 2020. As this resolution is issued by the Federal Ministry of Human Resources and Emiratization, the application of the resolution is directly aimed at non-UAE national employees of onshore private sector companies which are negatively affected by the crisis and or the precautionary measures by the government. The measures that are listed and can be taken by the companies are, as you can see on the slide, introducing remote work, requesting the employee to take paid leave, and with agreement of the employee implement unpaid leave, temporary salary decrease, and permanent salary decrease. From what I have mentioned, I would conclude that the aim of the resolution is that employers faced with a situation where their workforce exceeds their workload requirements due to the coronavirus outbreak should start with low impact measures before making use of more drastic measures. This means that employers should first ask their employees to take leave as compensation for possibly any overtime entitlements instead of such overtime being converted to payment claims. As a second step, employers are entitled to ask employees to take paid leave. According to Article 76 of the UAE Federal Labor Law, the employer may set the time frames of the employee's annual leave. This is an entitlement that employers certainly rarely make use of, which does not mean that such entitlement does not exist. What it would also include, for example, is that employers are free to dictate that overtime is being converted to days off. As a third step, employers may ask their employees to take unpaid leave. This is a measure that the employee will have to expressly agree to, though. Further steps include temporary or permanent salary reductions. Same as for the unpaid leave, these are measures that the employees will have to expressly agree to. Plus, according to the resolution, a specific annex to the official employment agreement will need to be signed by both the employee and the employer. How effective it will be for employers to find an agreement with the employees definitely depends on the relation that they may have with the employees, but certainly also very much on the way of communicating this to the employee. This would include that the intended changes are announced in a timely manner, giving the employee the possibility to arrange alternative provisions when being faced with a reduced salary, and at the same time incurring the same living costs, and especially when agreeing to unpaid leave, where there will be no income at all. What I see in the cases coming to me is that for a sole breadwinner to sustain a family, even only on a reduced salary, is already a challenge. But having no income at all may be for some simply too much of a hardship to agree to. In this case, what I have recommended to clients is applying different levels and percentages of salary cuts depending on the income, which would result in a higher percentage for the higher earners and a lower percentage for the lower income employees. A factor that certainly also plays a role is productivity. While many employees may claim that their individual work is also affected by the general downturn in business, this does not apply to all sectors. So when employers see that in the industry that they are working in, where the productivity of the employee would mainly depend on their own relation and engagement with clients and how much effort they put in, and there are, in comparison, employees doing quite well, even in the current scenario. This most certainly will give the opportunity for discussion on an individual basis, and in such instance justify that the employee may be willing to accept a higher cut. However, again, key is communication, and most definitely avoiding the impression that the solutions are just being handed down. This does happen, and I have seen many cases where the employees just accepted the decision that was presented to them, even without prior notices, just because they thought they have no other choice, and possibly also have concluded for themselves that even not knowing how long the whole scenario will last, that a job to go back to is better than having no job, possibly sitting idle and not even having the chance to return home. Having said this, I want to stress at this point that as employer, you have a contract with your employees which clearly stipulates that payment of the salary is an obligation. So basically, to decide to walk away from this obligation should not be taken lightly, and only after evaluating all options and most importantly, all legal consequences. So where does this leave an employer that possibly has exhausted all measures and cannot find consensus with the employee regarding unpaid leave and salary reductions? Well, why not inevitable, but most probably the employer will proceed with termination in events where the employee does not or just cannot agree to either unpaid leave or a salary reduction. Again, coming back to the way of communication, I have as an example a case that I also came across where the employee did not want to agree to the salary cuts, and the response from the employer simply was, "I really do not understand why you are fighting this. If you do not want to agree to the salary reduction, then you must resign." This is not only an example of clearly rock bottom communication, but certainly also unacceptable because the employee may waive certain entitlements when resigning, which cannot and should not be unilaterally dictated. When we look at the resolution, redundancies are not specifically listed in the measures, but are referred to in Article 3 of the resolution, giving a benchmark what will have to be observed by the employers to proceed with the termination. For one, the companies must have been affected by the precautionary measures, have a surplus of non-citizen employees, must register them in the virtual labor market system, and continue to fulfill the commitment in terms of housing and entitlements, except wage, until they leave the country or find other employment. I would like to leave you with a suggestion for a step-by-step plan summarizing what I have mentioned so far. Assess and evaluate the impact of crisis on your business. Consider measures to retain employees versus termination. Try to reduce liabilities by determining annual leave. If required, seek communication with your employees to achieve an agreement for unpaid leave, temporary or permanent salary reductions. Carefully consider and plan redundancies with legal assistance. And if a termination is inevitable, try to achieve a mutual termination. Even a reduced one-time payment may be more beneficial than a potential higher claim after proceedings at the labor court. With this, I thank you all for your attention and would hand back to Roshan.
Thank you, Elena. Thank you very much. And quite a number of questions would start coming in, and how you would do that is please put in your questions in the Q&A bar and make sure that you address those questions to Elena or to the speakers who are coming after this so that they can be addressed by the respective people. So I'll give you about 10-15 seconds to put in any questions that you have for Elena until we prepare with our next speaker. Good, thank you very much. And it gives me great pleasure to bring on our next speaker. He is Mr. Adil Shafi. He's the partner of Anjarwala, Collins and Hyder Motor. Adil joined the company in 2013 from Hyder Motor B&R and Company and was made partner in 2016. Adil leads the Pakistan desk at ACNH and has extensive experience in advising on corporate M&A and banking finance matters. He has assisted clients with the banking, energy, packaging, pharmaceuticals, logistics, as well as government entities, including Propaco, Government of Somaliland, Oman Trading International, City School of Pakistan, GEMS Education, Getz Pharma International, Al-Dabab Exchange, Derby Group, Aga Khan Health Services, Orison Solar Power Limited, Raha Group, and many more as such. Under his leadership, negotiations and completion on internationally acclaimed transactions also have taken place. So I would like to welcome Adil to take over and take us through your presentation. Over to you, Adil.
Thank you, Roshan. Good afternoon, everybody. I would first of all like to thank the BNI Forward team to give me the opportunity to speak to you today. And it is my great pleasure to run through some of these main legal aspects of what is happening to the labor market during these COVID-19 pandemic times. So Elena has already given us an indication of the resolutions which have come out by the UAE government to deal with the relationship between employers and employees. There are basically 3 resolutions which came out. 2 of them are mainly important for the expatriates and expatriate sector. So one of them is 279 and the other one is 281. I will spend a lot more time on 279 because there's a lot more in terms of practicalities that companies have to know when we're implementing resolution 279, and I will slightly touch on 281 while running through the presentation. So without repeating what Elena said, basically there have been 5 measures introduced by resolution 279. And these go in sequential order. They start from implementing remote working, granting employees paid leave, granting employees leave without pay, reducing wages temporarily, or reducing wages on a permanent basis. Now, in terms of practicalities, companies have to be they have to think through the processes that need to be followed when they're implementing these resolutions. As I initially mentioned, the government wants to see that you're actually implementing these sequentially. So for companies to start implementing this resolution, they need to be able to show on paper that at least they have tried to exhaust all options before they've gone for, so to speak, the nuclear option. And we have seen employers, who have done this without implementing the steps properly, and there have been cases in Labor Department which have been registered as a result of that. And I cannot stress this enough. At this point in time, communication with your employees, obviously everybody's sitting at home, or you may have 30% staff, which is a defense. Communication with your employees at this time is of the utmost importance. You cannot understand the situation which an employee would be sitting in, where they receive a temporary or permanent reduction annex of salary without any heads up of any nature whatsoever. And when we advise clients, we say that we should have a town hall, we should have some sort of meetings with the employees to run them through the problems that the company is facing. And more often than not, we have seen the employees of these companies being a lot more receptive to accept changes which are being implemented by the business. So one key point to note is that 3 of the measures require a consent of the employee. So no employer can take unilateral action. If they do, then you're opening your door for complaints at the Labor Department, or even complaints going to the UAE courts, which obviously adds an additional cost burden for defending them, and then penalties being levied on the business. As I'd mentioned, there's also resolution number 281. This basically is the so-called work from home resolution, which states that businesses can operate up to 30% capacity in the office while the remaining workforce operates remotely. As far as you're talking about working at the office, you have to implement certain measures. You have to make sure that there's frequent screening at the office in terms of temperature. You're providing them masks. You're providing them with sanitization equipment to ensure that everybody is safe. And you also have to make sure that you prevent your employees who are showing symptoms of COVID-19 from entering the workplace, or even the worker accommodation if you are providing your laborers with accommodation. So now I'm going to go into step-by-step of how 279 works. The first option, obviously, is implementing a work from home. Obviously, for brick and mortar businesses, this may not be the case, but this is for businesses which obviously can work remotely. So some rights and duties of employers and employees that I'm going to touch upon. Obviously, as an employer, you need to make sure that you're giving the right infrastructure to employees to be able to work properly. So that would be a laptop, that would be a secure laptop, Zoom access, and everything of the like. You obviously specify the working hours on which your employees are going to work. In terms of what employees have to do during performing their services, they have to make sure that they maintain confidentiality. You cannot have papers lying around in the house. If you're working downstairs from a lobby somewhere, you can't have papers lying around. You have to ensure that you're maintaining confidentiality. You have to ensure that you are accessible to your employer and other colleagues. So your employment contract says that you're working from 9 to 6. You have to make sure that you're available from 9 to 6. Just because you're not in the office doesn't mean that those obligations will not apply. Obviously, security requirements have to be adhered to. Just some tips for employers. Make sure that, as I said, provide fit for purpose IT to enable remote working. Keep in touch with your staff regularly. I mean, we advise clients that you should have a daily check-in Zoom meeting every morning. This basically ensures that your employees are up and running at 9 a.m. You also know that everybody's doing well, and basically it keeps the morale up in terms of your operations remotely. And again, I would like to reiterate: have a plan in place. We've advised clients on setting up plans of what they would have done were they implementing a remote working system at the time this COVID pandemic hit. And now, obviously, we're also trying to advise clients on what steps they need to take or what plans they need to roll out for their businesses and their employees once this COVID pandemic starts easing down and this 30% restriction also starts easing up. So it's very important to have a plan in place. And as I said, communication, it's super important. After remote working, then the second option that the employers have is putting staff on paid leave. As Elena also mentioned, the UAE labor laws allow the employer with the discretion to put an employee on paid leave whenever they want. So basically, this is the easiest option to follow. Obviously, it also, in terms of your end of service impact, if God forbid you have to implement redundancies, it also has a knock-on effect on the total amount that you have to pay, because at the time end of service gratuity is calculated, you have to also pay any accrued leave to your staff. So if in case there is any accrued leave available, then you will have to pay that to the employee at the end. So we have been advising clients who can implement it right now that if your staff is not working from home, you can, at the first option, implement a paid leave system and just put people on leave. This will also ensure that once the pandemic eases down and your business is back to work, you do not get a barrage of leave requests of people wanting to go home, and you're effectively left in the same situation. The other option is your unpaid leaves. These were not initially envisaged under the labor law, but Resolution 279 allows for that, provided that you have consent of your employee in writing. As you would have seen, the MOHRE has come out with a temporary addendum which needs to be signed if you're implementing some of the 279 processes. So you have to make sure that you get the temporary addendum signed with the employee and make sure that it's in your records at all times. And obviously, as I initially mentioned, make sure that you try and utilize the paid leave option first before you go into this process. The other option that's available is the temporary reduction in salary. Now, this again, you need to sign the temporary addendum, which I mentioned before. You have to obtain the consent of your employee, and you have to enter a fixed time period. So, I mean, we know clients who've put in time periods of up to 31st October 2020 as the time when the temporary salary reduction would be in place. So you have to put in a fixed time, put that in, get it signed off by the employer and employee, and keep that in your record. There is currently no clarity as to whether this has an impact on the EOSG, the end of service benefits. I say this because the end of service is calculated on the last 3 months drawn salary of an employee. So basically, an argument can be raised that if for the past 3 months during the temporary salary reduction phase, I am receiving a reduced salary, then my end of service may also be calculated on that basis. Not been tested as yet, to be honest, in quotes, but there is an argument that this can be raised. And just from a practical point of view, we've in our practice, we have seen that the temporary addendum cannot be uploaded on the MOHRE website. What they are alternatively doing is that they want you to log on to the portal, put in the details by individually for each employee, and they will then send an employee an email getting the consent from employee directly to the MOHRE as well. So just something to bear in mind when you're implementing a temporary reduction in salary for your employees. As I mentioned before, vital to keep records of signed documents with you for these temporary reductions, because the MOHRE has the right to seek this document from you at any time. And then the last issue is obviously the e-signature bit that I just mentioned, that you have to go through the MOHRE portal to actually implement this. One of the harsher options obviously available is a permanent reduction in salary. As with the temporary reduction, you need to have the employee consent, but in this case, you also need MOHRE consent. So if if I need to reduce the temporary salary of my employee on a permanent basis, I need to go to MHRE and seek consent. There is what's called an employment contract data modification form, which I need to apply for and then wait for MHRE to come back to me before I implement this process at all. The knock-on effect, and it is clear, at least as far as permanent reduction is concerned, is that EOSGs will result, the permanent reduction of salary will result in your end of service gratuity being lowered, the liability as such being lowered, because the basic salary is going to be lowered. Now, before you actually go into a redundancy program, there's a last option which the government has introduced, which is a virtual labor market. So the way the virtual labor market works is that if you have any excess expatriate staff which is sitting at in your business on your books, and you're not using them at this time, you can sort of register them on the virtual labor market, and they can try and find alternative employment for the time being. In that case, the basic salary costs are not to be covered by the employee, but you will obviously be liable to pay their housing and other allowances. The only importance of the virtual labor market obviously is that from NOPREC's perspective, you're not introducing a redundancy program. That's one. The second one is that you're obviously reducing your overall costs as far as basic salaries are concerned. And the third and very important thing is that when these things ease down and when business come back to normal, you will not have to incur the cost of incurring visa costs, training costs, and all those onboarding costs that you've already incurred, and a lot of time that you've incurred in training these employees because they're sitting on your books. So effectively, they come back and it's a plug-and-play situation where the employee just comes and they start working as they were before. Obviously, if none of these options are feasible, then there is a last option of implementing a redundancy program. Redundancy programs, obviously, as you all would be aware, there are two types of contracts. There's a limited term contract and an unlimited term contract. For a limited term contract, you cannot have a termination without cause. There is an argument whether, in light of the COVID-19 pandemic, implementing a redundancy program, would that be with cause or without cause? But the only downside with terminating a limited term contract is that you have a penalty of up to 3 months salary, which has to be paid, or the balance of the term of the limited term contract. And this is over and above the EOSG liability. So just something to keep in mind in terms of limited term contracts. As far as unlimited term contracts are concerned, you can follow through the notice period in the contract and try and implement a redundancy program. Obviously, as the concept of redundancies was never recognized in the UAE before, and it's still not recognized, there have been some mentions of it here and there, including in the resolution. We still don't know how the courts are going to take this, and whether, in our experience, if an unlimited term contract employee is terminated without cause, we have seen instances where the court has awarded 3 months penalty in addition to the EOSG. Our advice to clients for unlimited term contract termination has always been, let's implement a plan. If you're planning a redundancy, we have to make sure that the plan is implemented properly, legally, so as to ensure that if you have to pay that 3 months, we try and reduce that as much as you can. Because you already have to pay USG, you have to pay the accrued benefits. Why not try and reduce the 3 month cost, because that is paid on the actual salary, not on the basic salary. So that's very, very important in terms of thinking if you have to go into the redundancy options. Some practical implications in terms of employment termination. As you all know, an employee has to leave the country if they can't find alternative employment within 30 days. Obviously, big issue now, flights are not working, you can't repatriate staff. So you can agree to keep employees on your visa as long as you cover their employee health insurance costs and everything else. Just in case of maintaining goodwill and ensuring that if people are here, they're at least protected to the extent possible. And obviously, if they're on your visa, you have to ensure that medical insurance is in place. And towards the end, EOSG is the big liability. We don't know of many businesses which actually have adequate reserves to make payment of the EOSGs. So if you're implementing a redundancy program, we also have to sit down and think what you need to do as far as paying that EOSG is concerned. There have been certain cases where we've advised people on doing an installment system for EOSG. Some employees agree to it, some employees don't agree to it. But obviously people look at it, we've seen a lot of employees looking at things from a practical perspective, because either you get paid or you don't get paid. So at least with an installment system, we have seen situations where they're agreeing to it, Obviously, when you have an installment system, you have to make sure that you enter into an agreement, you enter into a proper binding contract, and you give employees comfort in terms of ensuring that you are making punctual payments. You can't have a situation where you pay 1 month and then you just run away and the employee doesn't get paid anything. So just some things for you guys to think about. Thank you very much for your very kind attention. And I look forward to talking a bit more about this during the Q&A session. Over to you, Roshan.
Thank you, Adil. Thank you very much. So I'll give our attendees a few more seconds. Start putting in your questions for Adil. And as mentioned, they will be answered at the end of the next speaker. And incidentally, our next speaker, what I would also suggest is he has another commitment, and he would be leaving this webinar at around 4:15 p.m. So what I suggest is, while his presentation is going on, if you can key in any questions that you have along the way, so that those can be addressed first by Preetham before he takes our leave. So questions to Adil now, and questions to Preetham as he commences his presentation. So let me first introduce Preetham to all of you. Gable Preetham Nathan, he's the chairman of Nathan Group. He has over 30 years of experience in strategic human resources and management consulting across FMCG, banking, engineering, oil and gas, hospitality, healthcare, outsourcing, and technology. He has supported CEOs, board members, and shareholders in strategic initiatives across mergers and acquisitions within human resources, change management, organization design, human resources architecture, technology management, organization development, talent acquisition, performance management matrix, and balanced scorecard. Career and succession planning, compensation, rewards management, learning and development, team development, etc. are part of Preetham's. He's also, today, his group of companies manages a large portfolio of diverse organizations and across industries within the Middle East. The entire gamut of human resources are being managed by him for those companies. Prior to his current role, Gabriel previously was the head of human resources services for Emirates NBD Group, comprising of both Emirates NBD and Emirates Islamic Bank, two giants in the banking industry. So over to you, Preetham, and take it away. Thanks.
Thank you, Roshan, for your kind words and introduction, and good afternoon to all the listeners who are online. Stay safe and healthy, and welcome to this webinar. I'm going to take you through the practical aspects of human resources and subsequently cover what's important in terms of what from a humane aspect. Today, you see a number of industries struggling. Among some of them are event management, with all events being canceled today in the UAE. You find it hard-pressed for the event management companies to even survive in this COVID-19 situation. The travel industry with no travel, no holidays. The travel industry is in doldrums. Suddenly all cancellations, bookings are canceled, no tickets being issued. Move on to the hospitality and leisure industry. You have a similar situation with a lot of hotels running at no occupancy with huge investments and manpower running those various hotels and leisure facilities. You take the food industry with the complete lockdown, people are hardly visiting any of the restaurants these days. And the new guidelines are going to restrict the number of visitors. And the list goes on and on and on. And as we move on, you will find what is the implications of all of this today. The current trends in the market, you will see are salary cuts being implemented. And what we have seen from the various companies we are looking at and managing and those we are not, salary cuts ranging between 10 to 50% across the board for all staff. Some at a higher level, some at a lower level, depending on where you are positioned as such. As a priority, any annual leave which has been accumulated first gets looked at and addressed and gets taken before they can look at anything else. They ensure the continuation of the employment visa and medical because that has already been paid for all the staff. So if you can keep them and look after them by actually looking at reducing the Ministry of Labor contracts to a figure which is affordable to organizations, or even as low as dirhams 100, you can ensure their continuation in the UAE for the period and duration of their visa. This ensures they have a fair chance in the labor market, which is going through difficult times. But then if nothing of that is possible, one can always look at the loss of pay situation till the situation improves. And finally, we have also seen organizations across the UAE looking at the poor performers right at the bottom of the performance curve. We look at the normal distribution at the bottom 5% being identified and being made redundant on performance. So we have a number of aspects today which is going on. With all that is going on, we see around us. What's next for industry? What's next for your organization? What's next for you? Have you asked yourself that question? What is going to happen in the world as we move on? Is it going to come back to normalcy and the same, or is it a new normal? And what is the new normal? So what is next? We are already seeing a number of organizations across the board, right from extremely large organizations to medium size, approaching us to look at outsourcing support. Outsourcing across all support functions, whether it's human resources, whether it's accounting, whether it's IT, and the list goes on. At the same time, you can look at flexibility in staffing, so you don't have to bring back permanent staff because you never know what's going to be there tomorrow. So if you can have flexibility in your staffing with outsourcing at the same time, you can manage a situation which comes up unexpectedly tomorrow, and also manage your organizational needs as they scale up or scale down depending on workload, depending on summer months, depending on festival holidays and things like that. So the question you can ask yourself is, if this is next, how is it done? How do you approach it? We are in the business of outsourcing the human resources function, and we manage more than 5,000 staff across the UAE in terms of outsourced support functions, both in strategic and operations HR. And some of the names are some of the largest industry names today in the UAE, right from the #1 organization in the UAE to much medium-sized and small SMEs as well. So the focus of outsourcing provides for the organization to focus on their core competence, know what they're doing, address the business requirements rather than look at support functions, which is not their core competence. In addition, temporary staff can fill those vacancies, and short-term staffing provides the opportunity to ramp up the workforce. Why are we suggesting outsourced functions? Because when you manage huge number of outsourced staff across different industries, we are sharing a shared platform, a platform where the learning across industries is brought in. And this learning is taken to the organization which we are managing as an outsourced industry. So we bring in the leadership, the know-how, the expertise across industries to that one company, which gives it much more than having a staff internally. And that's where contract staffing or temporary staffing come in. Because with contract staffing, you can actually outsource those roles, or those temporary roles, or those permanent roles, and scale based on work demands for your organization. Therefore, you need to make a group of core people working internally, and the rest supporting through contract, outsourced, or temporary staffing. And when you move on, you will find in the next slide that it reduces your cost to the company. A cost today, the bottom line is so important, given the economic downturn, given the impact of COVID-19 on balance sheets, given the issue of cost. So why not address the cost arbitrage by outsourcing at a lower cost? Why not address the cost arbitrage by hiring technical and other managerial staff on temporary or contract staffing at lower cost, whilst paying the same amount of salary, but at lower cost and benefits, thereby reducing your cost? Why don't you look at convenience in hiring? When you look at what's happening in the Western world, you will find 50% of the workforce in the Western world is outsourced and not internal. So they are able to attract skill sets which are diverse, which are varied, which are new, which bring a fresh perspective to the table. So why can't organizations look at bringing perspectives which are different from always keeping them internally. So when you look at skills and competencies for contract staff, addressing platforms across the board, across industries, the ideas and concepts that provide a huge boost in productivity to these organizations at reduced cost and ensure your cost arbitrage at the same time. This, we believe, is what's next for industry across the world. And with this, I would like to open for any questions that you have to ask. And thank you for your time and thank you for listening.
Thank you, Preetham. Thank you very much. Now, as I said, please start putting in your questions to Preetham because he probably has about 20 minutes before he leaves us in terms of the webinar. And also questions that are coming in for Elena and Adil, please make sure that you tell them, who those questions are addressed to. So now I'd like to hand over to Deva, who will moderate the questions that we have coming at the moment. I can see quite a number of them. And Deva, over to you.
Yes. Hi, good evening, friends. Thank you for, good afternoon, friends. Thank you for joining us today. And now coming to the question and answers of these questions, which have come up as of now. I'll start with the first question to Elena, as we are awaiting questions for Preetham. When we are going into the first question, I find it very interesting because he's somebody who is really worried about the ladies here. So let's look at it. In case of employees employed based on husband's visa, is the law same? I mean, you were mentioning about how the labor law works. The wife in husband's visa, how does it work? Elena, over to you.
Thank you very much. I would very much believe so that is the same because even on a husband visa, you have to register the employee with the Ministry of Labor. They get a labor card, and so the conditions are the same.
Excellent. Thank you so much, Alina. The next question also is to you, so I'll just finish with that question and then wait for questions for Preetham. Yeah, interesting question from Hermione. How long do labor cases take once you file them? On the
That's a very good question. Well, in times like these, you don't really know, but I mean, the experience, what we've seen, it goes a couple of weeks or to a couple of months. That's really depends on the cases, what it is. That is hard to say. I mean, maybe Adil has a different experience on whether there is a general rule of thumb, but I would very much say how complicated the case is.
Over to you.
Thanks, Deva. Thanks, Elena. Yeah, I would agree. I would agree with Elena. Obviously, not every case is the same, and therefore timings are not always the same. But in terms of first instance judgments or first instance results, we generally end up seeing them within the first 2 months at most. Obviously, when things get complicated, when you have rights to appeal. So we've seen cases where final judgment is issued in 6 months or maybe a year and a half. But you will get that first paper judgment very soon. But then obviously to go right to the end, it does sometimes take time.
I'm sure it's all a matter of time once you sort out the issues. I'll take the next question for Adil. Adil, we have an anonymous person giving us a question here. Does the court take swift action against the employers who terminate employees? It's the other way around.
In our experience, yes, because when you go and when an employee goes and complains, they go and complain to the Labor Department. And in terms of getting a result at the Labor Department, that is generally fairly quick and swift. And if obviously parties are unable to reach agreement, then it goes to court. But in terms of being fair, we've always seen that the Labor Department will try and protect the employee, because in terms of negotiating power, they are a less favored party. So we do see results coming in their favor quite quickly. But then obviously, as with the link with the first question, there are timelines in terms of once you go into the court process, but it is swift and generally fair.
Yes, that's the reason. Yeah, thank you, Adil. That's the reason I need to take it on a continuous basis, because it was a related question. Sure. Going back to a question to Elena, how about termination of employees that are in their home country? Do we need to register them on the virtual job market? This is a nice question from our BNI member, Puneet Shah. Can you elicit on that, Elena?
Well, I would think that in practical terms is a bit difficult, because if what Adil has mentioned in this presentation, that the purpose of the virtual labor market is facilitating work for the employee, and that enabling him to work for another employer, then that might be difficult if he's outside the country. So I'm not really sure that this would be the case.
Thank you, Alina. And moving on to a question to Adil from Mr. Navanida Ratnam Balsan. Trust the travel allowance not covered in the contract doesn't become liability to pay if employees claim.
So I'm assuming in terms of travel allowance, what the question is that whether I have to give a yearly ticket if it's not in the contract. In terms of the labor law, there is no requirement to give a yearly ticket until and unless it's not in the contract. But obviously, if you are terminating an employee, then you have to make sure, and they don't have any alternative employment in the UAE, you have to make sure that you give them that ticket, at least so that they can be repatriated to their home country. But no, to answer your question, if it's not in the contract, if it's not part of the benefits, then no.
Yes, thank you, Adil. And we have a nice question to Mr. Preetham from Ms. Noble. What do you think the workplace will look like beyond this crisis?
In my view, I think the workplace will be completely different. It's not going to be it's not going to be the same. It'll have a new normal. Like I'd mentioned, you'll have a lot more outsourcing going on of support functions. You'll have a lot more contract staffing or temporary staffing coming in. We are already seeing a lot of inquiries in that area. We are from large organizations, medium organizations, and small. Therefore, the trend is slowly shifting, but the shift is taking time as people come to grips with the new normal. And therefore, the workplace will constitute of a core team, which will be possibly staying with them and some working remotely, but a lot of the work being outsourced. And this is how I see the new normal.
Yeah, thank you so much for that, telling us more about how the workplace is going to be, and I'm sure outsourcing is going to be the thing. Yes, let's go to the next question. He has not mentioned whom it has to be addressed to, but then I'll read it out, and I think Elena or Adil can take up the whole question. A pretty long question from Aslam. In current situation, what are the Labor Department guidelines in case employee's contract is due for renewal and employer is not interested to renew? Okay, employer is not interested to renew. What would be employer's responsibility in terms of salary, end of service benefits? And due to lockdown, employee is not allowed to return to his home country. Whether employer is responsible to pay salary for that period. Who is going to take, whether it's Elena or Adil? I think I'll start with Elena.
Let Adil start.
Okay, so she's passing the buck. Over to you, Adil. The buck is passed to you.
I don't have anybody doing that. Okay, no, thank you, Deva, and thank you, Aslam, for the question. An interesting question, because you've got two issues happening here. One is that the contract is coming to an end, and I understand that there is a certain time period where there may be liability to pay salary because the contract term isn't over. In terms of people who are outside the country, effectively, you can't really follow all of the processes which are set down in the 279 resolution. So the first option is obviously utilize some of the time period in terms of their annual leave first, try and kill that period off. And then for the balance period, if they're unable to work or if they're unable to do anything for you during that time, try and get them to agree to an unpaid leave. And then obviously, in terms of termination, it is solely your right to not renew the contract. I'm assuming this is a limited term contract. It's your right to not renew it. And then based on law, you end up paying them whatever the end of service gratuity is, which is calculated on the years of service that they've completed. And apart from EOS, you'll pay them, I would want you to finish the accrued leave beforehand, so you pay them anything else that is in terms of commission or anything that's due. At least that's my point of view.
Thank you so much for answering that question. I think I'll move on to Mr. Preetham because he has to leave at 4:15. So I have a question to him from Ganesh. What are some tips to reduce benefits without spoiling employee morale? Wow. Nice below the belt question.
That's a very important question being asked by a lot of companies today because of the cost of employee cost. One way we're looking at SMEs being able to actually, when you outsource, and you outsource to a company like us, because of the sheer volume of number of staff we are carrying, we get better rates in insurance products. We get better rates in booking when you're booking through travel agencies, and we represent a large travel agency as well. So we have options in that front. The other way to actually reduce is benefits they don't see on the spot, like your end of service benefits or gratuity as they call it. You can give the same amount of money, but lower their basic salary a little bit. So your cost on your gratuity in the long term doesn't go up, you know. So the employee morale is still very much solid in the ground, and they're not affected to look at something in the future is going to get affected. Whilst the total cost to company at that point of time gets addressed and paid to them. So you can look at that option. You look at ticketing option in terms of flying them on days where it's not peak travel, where you don't have festival or holidays. You can look at that option. You can look at your medical option, especially when you outsource staff to people like us, and we get better rates on medical. These are some of the points which we look at when we address benefits reduction for staff. I hope I've answered what you want, Mr. Ganesh.
Thank you, Preetham. I think he did a little outsource business promotion there too. Wonderful. And when you look at, yes, when you look at all the questions coming up, I think more towards the lawyers. So let me get on to the next question. Hi, Adil. If an employee has traveled outside before the lockdown and stuck abroad, is not able to work from abroad. Okay, we addressed the question of what happens when he's here and you don't want to renew. But what is the employer's liability in the scenario for salary payment during this period until the employee is able to travel back to UAE? A very interesting question. Over to you, Adil.
Thank you, Deva. Answer would be somewhat the same. Obviously, if they're not able to work remotely, exhaust your annual leave. Try and agree with the employee to go on unpaid leave during that time. If that does not happen, then unfortunately you have the liability to keep paying the employee because they are on your payroll. Worst case scenario is then you try and implement. You may not want to, but in order to curb the cost, you may try and implement some sort of a termination arrangement. And as a result of that, there is that 3-month penalty which I was alluding to in my presentation. But considering the current COVID times and obviously the physical restrictions that you're talking about in your question, there is a chance that the court may take a light view in terms of that arbitrary penalty. Obviously, that's not been tested yet, but there is a good argument for that because everybody is going through some sort of a difficult situation in light of COVID-19. So that's somewhat of a short response to your question, Chetan.
Yes, thank you, Chetan, for that question, and thank you, Adil, for answering it. Now, let me get on to the next question from Dr. Anil, again to Adil. does the employer has the choice of appealing in the court?
Yes, of course. So if the first instance result comes in the favor of the employer has a chance to appeal. Obviously, you need to have a reason for why you're appealing. But yeah, it's not like the employer has no rights. Absolutely, you have a right to appeal.
Yes. I have another question. He has not mentioned whether it's to Elena or Adil. Either one of you can take up. Okay, he has mentioned his name. My name is Jacob. I have a question. Every meeting have discussion for salary cuts. Instead of cutting salary, give some half payments after the issue finish. Oh, I think it's I'm finding it difficult to understand his question. Half payments after the issue finish, market is okay. Then pay balance, this is possible. Yeah, okay. Yeah, I think I understand the question. I'll put it to Elena here. Elena, what he's asking is, can he give part payments now and then promise to pay them when the balance payment when the market is okay or the market opens up? So he's being a very considerate employer. What do you think of that, Elena? Is that possible?
I would principally say that this is possible, but the employee has to agree, the same as they have to agree to salary cuts. It's basically also only getting a payout for a part of the salary. Then, you know, it's a deferred payment basically. So I would say if the employment agrees to it, then it should be okay. But I would suggest that it should be documented and put in writing for the employer not to lose, employee not to lose his claims.
Yes, thank you so much, Elena, for that. And we have a very interesting question from Amit Vardhan. I have employees with 40 to 60 days accumulated leave and will start taking after the lockout in peak times. How can we handle this? Interesting question. I think I'll leave that to Preetham to answer, being an HR person. I think it is better for him to answer how to handle these leave issues.
Yeah. If you have 40 to 60 days accumulated leave and you start taking the lockout period time, how can we handle this? After the lockout, it doesn't make sense when you have 40 to 60 days leave. It's better to take those leaves during the lockout period because then you're addressing non-working days with the leave being taken at the same time. If you accumulate the leave after the lockout, then you have to give them the leave after the lockout or you pay for the leave. You can also buy the leave out. Now, there are two different ways of looking at buying leave out. In Dubai, it's different. In Abu Dhabi, it's different. In Dubai, they're willing to look at basic salaries. In Abu Dhabi, they want the total salary. So you have both options when you go to labor. So the option is to see whether you can buy the leave out. And if you're not willing to do that, give him the leave now. Or spread the leave out over a period of time where you can talk in terms of taking leave in blocks every quarter so that he'll be able to finish the leave from this year to the next year, and thereby being able to exhaust the leave that he's accumulated.
There you are. Yes, thank you, Preetham. There you have from an HR specialist. You have the answer, Amit. And I'll go to the next question. How about someone's contract getting over this period and we can, yeah, that's the same question which he has much before the, renew the contract much before the COVID situation. Of course, it's a related question, Adil. What he says is, it is not currently, but the contract, he doesn't want to renew from the previous time itself. How would you handle that, Adil?
So, sorry, just so that I'm clear, and they will help me with this. Yeah. So what he's saying is the company decided not to renew it, but the expiry actually is happening during COVID times.
Yep, yeah, they have decided much before the COVID times, but the expiry is happening during the COVID times.
Yes,
that is
I mean,
from this question. Yeah.
So if the intention is that they finish their remaining term of the limited term contract, then you're fine not to renew it. Obviously, if you're terminating beforehand, and even if you decide to terminate beforehand, then with a limited term contract, it's quite clear that you have to pay up to 3 months in terms of arbitrary dismissal fees or the balance of the contract. If it's 1 month left, then you pay that. But yeah, non-renewal can be done as long as you're doing it towards the end of the contract term.
Yes. Thank you, Adil, for that answer, because it's a related question from the earlier answer. I have another question from Amit Vardhan. I'm going to dismiss the question for the basic reason that it is out of this topic, and he can pay Adil and get the opinion from the lawyer's mouth.
Thank you, Deva.
And coming to yes, another question. Good question from Amit. I'll take that question. Adil, is it that even if the guy is not working and caught outside, we have to pay salary?
Unfortunately,
I understand the question to be that he's not working, but he's caught outside.
He's outside the country, I'm assuming.
Yeah.
Yeah. So Amit bhai, unfortunately, the answer is still yes. And as with the previous answers that I'd given, you should, if this guy is somebody who has the 60 days annual leave, please utilize it, and then agree on going on unpaid leave, or worst case scenario, then if this lasts very long, then you try and see what you can do in terms of termination. But agree on unpaid leave. If they're not working, then just in terms of just something, and I may be going slightly off topic, in terms of practicality, we have seen majority of employees actually understanding the issues of businesses that the businesses are going through. So they seem to be very receptive. Obviously, it has to be communicated properly. Nobody better than you, Amit bhai, to actually put that through. But you have to communicate properly, and I think that's the way you'll probably get a solution to this. But yes, you have to pay salaries if you're not implementing anything else.
Thank you, Adil. And I feel like an airline staff now. A last call for questions to Preetham. We have 2 more minutes for him to leave. So this is the last call for any questions you have to Mr. Preetham here before he leaves the webinar. So feel like an airline staff. Okay, let's get on with the existing ones. And I have a question from Mr. Khalid to Elena or Adil, whoever can take it up. Are these rules, regulations equally applicable to free zone companies like Rockies, for example? Will these rules apply to the free zones as well? Interesting question.
Well, my view would be that they are in principle, because it's a federal law, and free zones might have their own regulations. I would say DIFC and ADGM are excluded, but even though they would have their own slightly different rules, if it comes to case that has to go to court, it's still the federal law would apply. So I would assume that the same rules would apply. I don't know how Adil sees this, but this would be my view.
Thank you, Lena. I agree. Obviously, there are so just to highlight, there have been some free zones which have actually come out with their own virtual labor market for people within that free zone. So you just have to make sure that if you're using the virtual labor market system, you use your own respective free zone. But in terms of the other processes which are set down in Resolution 279, it's federal law, and we've seen in the past that as far as labor law is concerned, we have seen, except for ADGM and DIFC, people applying what's on in the federal law in free zones as well. So yeah, I agree with Elena.
Thank you, Adil and Elena, for jointly answering that question. And yes, another interesting question about sales incentive from Iftikhar. If sales incentive is pending for the employee and the employee is terminated or resigning from the company, will employer be liable to pay the pending incentive? If employer is not paying, then what option employees have? Interesting question.
That's for me, is it?
Yes, that is to you, Adil. Yeah.
Okay, lovely. Thank you, Deva. So yes, very interesting question, because obviously some of the sales incentives are never in the Ministry of Labor contract. So, you don't get an automatic calculation for that. But as long as the sales incentives and the manner of calculation, including previous amounts which are accrued, are set down in writing, there is nothing that stops from an employee claiming that at the time when the end of service is being calculated or being paid. If the employer obviously says no, you are well within your rights to actually go to the Labor Department, complain, show them the documentation and file a case that these incentives are due, and you will be obviously settle those, and the Labor Department or the courts will try and get that in your favor. Thank you.
Yes, excellent. Thank you so much, Adil, for that answer. So I think Pritam has to leave now, so we'll bid bye to him and get on with our.
Thank you, Pritam.
Thank you very much, everyone, and have a wonderful time answering questions to both Alina and Adil.
Thank you so much for joining us. And let's get on with our two wonderful lawyers here with the rest of the questions. Yes, very specific, Adil. Of course, we have answered on a broader aspect, but he has become very specific about the notice period. We have a nice question from Chetan Kotari. We have a situation where an employee has resigned on 28th Feb and serving his 3 months notice period, but traveled out and stuck abroad and unable to work. Is the employer still liable to pay salary during this notice period?
Yes, contractually, yes, you are. You are liable to pay salary during the notice period. So that is the short answer. I'm just thinking, and I don't know whether Elena has a view on this. If the chap has any accrued leave, you can try and utilize that during that notice period to reduce your overall compensation, because you won't have to pay an additional salary when you calculate the EOSG if there's any additional leave left. But yeah, for notice period, you're liable to pay salaries.
Thank you, Adil, for that answer. But I have a little interesting tagline to go behind that. I am just wondering, logically, that he was serving his notice period at work, and why did he travel out of the country? I mean, still wondering.
That is also interesting.
Isn't it?
That's an interesting. It is, and actually, that's a very interesting twist, and great catch there, Deva, because either he left with permission or he didn't leave with permission. You never know. But yeah, I guess. But then we're going into the category of trying absconding or somewhere of that sort. So
I presume so, because if he has traveled without permission during his notice period, then it's a very tricky issue. Unless that he has taken his annual leave or notice period, of course, it gets.
That's a different story. Yeah.
It seems to be a very interesting twist to the issue.
Oh, we got to follow up.
We have the answer here. He did not take pre-approval leave and travel in anticipation. I think you have the answer, then you can go ahead.
Well, then you have so see, the thing is, if somebody does not report to work while they're legally required to, you can file an absconding case, and you also have rights to do a summary dismissal under Article 120, which basically sort of takes you away from the salary requirements, and then it also takes away the liability of the employer to settle EOSG. So there are various processes that you can follow. If he's gone without notifying and traveled in anticipation, he didn't anticipate what's going to happen to his salary and the benefits as a result of this. I'll leave it over to Deva or Elena to add if they wish to.
Elena, do you want to add anything to this?
Well, I'm assuming that the case was that he didn't travel work related. So because that if during the notice period, still the employer would still be obliged to work. So if the trip was work related, then of course all the entitlements would be there. But if it's not work related, then I think no.
Yes, that is interesting, Elena. Thank you so much. And I think I would say that the best option he would have is Article 120 to terminate the staff who has gone without a pre-approved leave, and save a bit on the end of service benefit as well as an employer, if Chetan is the employer involved. So coming to the and that too he has added on, saying that he didn't want work-related leave. So it is an easy way out to use Article 120. I mean, talking about, as Adil has raised this Article 120 topic, I would like to raise something about Article 120. If the worker is unable to come and join into work, and he refuses to work, we do have situations where there are staff who are not ready to come into work because they feel it's not secure, it's pretty insecure to do that. So what do you think, Adil? I mean, how can we handle that? Can Article 120 be used against those staff to dismiss them because they are not reporting to work on a, say, for example, on an essential services situation?
Well, I mean, if you're going into essential, then I'm presuming that you can't remotely do the work that you're supposed to do.
Obviously,
yeah. So look, the thing is that if employees are not willing to come into work, first of all, just so that we comply with the tagline that you have to have a humanitarian aspect to this as well. You have to try and understand and ensure why the employee is facing is raising that issue if they are raising it, and try and alleviate any concerns that way to try and make them a bit more comfortable. Obviously, if they don't end up coming and showing up at work, then I would think that there is a very plausible argument for Article 120, but I wouldn't invoke it straight away. I would try to go through a process. I would send them notices. I would at least wait a few days, and I would actually start the process in a way so that we can say that you're non-reporting to work and actually effectively means that you're out of the country without permission, because you're at home without permission. So in my view, I think you can sort of raise that, but it has to be. And I've seen this with some employers who try and use Article 120 in an arbitrary fashion, and they just throw out a notice, and you get stuck in labor. So you have to be very careful when you use it. But I think there can be an argument raised. We can do it.
Yes, excellent. Thank you so much, Adil, for that beautiful answer on Article 120. Because I wanted to ask you, because you had raised that article when you answered your earlier question. Now, something very interesting which comes up in this sort of scenario, again, a below the belt question, is that now, when you reduce salary or when you ask them to go on no pay leave, you need to get the employee to sign up a format which is given by MOHRE, so that there is an agreement between the employer and the employee. But what happens if the employee refuses to do it? Like he's not ready to take a salary cut, or he's not ready to go on a no pay leave. There are, as you rightly said earlier, employees are ready to understand, and they are understanding that the employers are also hands tied with lack of business and things like that. But what if they be unreasonable and say, okay, we cannot accept it. You don't have business, but you still pay us. What happens? I mean, how can this be handled? Over to you, Arvind.
Thank you, Deva. In terms of my view, it's obviously, if the employee doesn't accept to sign, then the employer's hands are tied effectively, that either they continue incurring the cost or they go into a redundancy program, because there's no gray area here which you can follow, right? Yeah. So obviously at that time, then the employer has to come out with a redundancy program and try and implement that. But the underlying and overarching issue over there obviously is the gratuity, and possibly the 3-month arbitrary dismissal fee. But as I mentioned, that we are taking a view that it can be argued that the 3-month arbitrary dismissal fee may not apply in this case, or the courts may take a favorable view. But to answer your question in a very short process is that then you're left with the nuclear option. Or you can also try and put them up on the virtual labor market, because they are excess staff for you. But you're still paying them their benefits, but you're not paying them basic salary. But yes. Then, and then the employers obviously have to consider that if they are doing this right now, do I actually want them on my payroll in the long term, once things go back to normal? So that's also another question that the employers when they're considering redundancy issues they need to think about. Because you stick together, right? That's not what's happening here.
It has to be, I'm sure it has to be a mutual thing. Thank you so much, Adil, for taking up that little complicated this thing. Over to Elena. When you talk about women working with husband's visa or father's visa and things like that, do you see that employers treating them differently because they already have a visa in place and it's easier to make them redundant than the people on the visa? Do you see a trend towards that, Elena?
No, not really. I have not experienced this. It really depends on whether there is the job required or not, but not just because they already have a visa that it's easier, because they're entitled to the same process has to be followed, and they still have to pay the same entitlements and claims to the employee.
Yeah. Thank you so much, Elena, taking on the ladies' point of view there. Thank you so much. It's 4:26, time to wind up. Over to you, Roshan, to wind up the session. Thank you so much. Thank you for all your answers, both Elena and Adil here.
Thank you.
Thank you, Deva. Thank you to Elena, Adil, and also Preetham, who had to leave us a bit early. A lot of technicalities, a lot of legal jargon, but we have to listen to that. And it was a very insightful, very good the opportunity for all our attendees to gain some good insights as to how we can face the challenges of the legal situations with your employees at the moment, and also what we can look forward when we are back to normal, or the new normal, if we may say. Just a quick reminders for you, as we do every week. We have Wendy Shaw, her name and number and email addresses are over there. What it is all about, it is a helpline for you, our members. If you are challenged and you need some sort of a support, Wendy will ensure that you get connected with someone very confidentially, so that they can be of support to you in these challenging times. We also have Anna, who you can reach out to in the email address and telephone numbers given out there if you would like to be involved with BNI Forward on any speaking opportunities. And we welcome any of you who would like to come forward. We then finally have 2 CEU points that all of our BNI members can log in through BNI Connect. And we also have a Facebook group, a private group, which is known as BNI Forward. We encourage you to join on and take these conversations forward that you have heard today or even in the past. So please do join the Facebook group as well. So we've come to the end of this week's session. We'll see you again in 2 weeks because it's the Eid week next week. And June 1st, we will have the wellness sessions. And 2 weeks from now, we will still come back to you with the business sessions. So I take this opportunity to wish all of you Eid Mubarak, and stay well and stay safe. See you next time.